Hello, today we're talking about 46.15 of the Texas Penal Code, and it's probably one of the least known statutes in the Penal Code. And it's interesting because it's the exceptions statute. So basically it's titled non-applicability, and it basically makes legal carry that otherwise is statutorily prohibited. So it's a statute that you really need to be aware of and familiar with, and you'll find that it probably helps you out. So for 2021's constitutional carry, they amended sections B, J, and L, and they added subsections M, N, O, P, and Q. So let's talk about them. So subsection A did not change, and this is basically what I call the cops, judges, and prosecutors exception. And so sections 4602 and 4603 of the Texas Penal Code do not apply to 1. Peace officers or special investigators, and then it goes on, so basically peace officers, parole officers, and neither section prohibits an officer from carrying a weapon in this state if the officer is engaged in the actual discharge of the officer's duty while carrying and in compliance with the policies and procedures adopted by the Texas Department of Criminal Justice regarding possession of a weapon by an officer while on duty. 3. Community Supervision and Corrections Department officers appointed or employed under Section 76004 Government Code, and neither section prohibits an officer from carrying a weapon in the state if the officer is A. engaged in the actual discharge of their duties while carrying, and B. authorized to carry a weapon under 76051 of the Government Code. So if you are a parole or probation officer, you're going to be exempt from gun carry if you meet those criteria that we just mentioned. Number 4, active judicial officer, basically a judge who has a license to carry. So if you are a judge in the state of Texas, you really want your license to carry, because that's going to make it where you are basically carrying the same as a police officer in the state of Texas. If you do not have your license to carry, then you are basically treated the same as an ordinary citizen for carry purposes. Subject to the caveat, like I said, in 4603, where it talks about officer of the court, that could be argued that lawyers and judges are officers of the court, but that's not how it's generally been interpreted from most folks. I think they misinterpret it to mean bailiffs when, as we know, with statutory construction, the legislature is presumed to know what they're doing, which we know time and time again when they enact conflicting statutes or they enact conflicting amendments or whatever. So we know that they don't always know what they're doing, but they're presumed to use the language that they use and intend to use that, and that the meaning of that language is supposed to be met. So when you use the term officer of the court, that's a lawyer or judge, that's not a bailiff. And there are statutes where they use the term bailiff, so they clearly know the difference. But that's a side point. Number 5, honorably retired peace officer or other qualified retired law enforcement officer as defined by 18 U.S.C. Section 926C, who holds a certificate of proficiency issued under Section 1701-357 Occupations Code and is carrying a photo identification that is issued by a federal, state, or local law enforcement agency as applicable, and that verifies that the officer is an honorably retired peace officer or other qualified retired law enforcement officer. That basically ties in with LEOSA, so retired law enforcement officers are required to maintain their gun proficiency, and then they're allowed to carry the same as before they were retired. Number 6, the Attorney General or a United States Attorney, District Attorney, Criminal District Attorney, County Attorney, or Municipal Attorney who is licensed to carry a handgun under the Texas License to Carry statute. So basically, your prosecuting attorneys with the license are treated the same as peace officers. Number 7, I don't know why they did 6 and 7 separately, but 7 says Assistant United States Attorney, Assistant Attorney General, Assistant District Attorney, Assistant Criminal District Attorney, or Assistant County Attorney who is licensed to carry. So again, prosecutors with a license to carry, 8, A bailiff designated by an active judicial officer as defined by 411-201 of the Government Code, who is A, licensed to carry under the Texas license to carry laws, and B, engaged in escorting the judicial officer. So you can be a bailiff, and again, I don't really know why they are specifying that there unless they're envisioning a civil bailiff that's not a law enforcement officer. 9, a juvenile probation officer who's authorized to carry a firearm under section 142.006 of the Human Resources Code. So that's a specific code, not the license to carry statute. If you're a judicial probation officer, you need to look at that section and see what it takes for you to carry. And 10, a person who is a volunteer emergency services personnel if the person is carrying a handgun under the authority of the license to carry statute and engaged in providing emergency services. So that was a newer enactment. I think that was 2019. Basically your emergency services folks, your firefighters, your EMTs, and that sort of job capacity, if they have their license to carry, they don't have to disarm while on duty. And that was for their protection. And honestly, that should have been the law long ago, but it is what it is. So subsection B was amended to read sections 4602, which is your basic areas, 4603A14, which is your government meeting locations, and 4604A-1 and 4604A-1, which is criminal street gangs, believe it or not, do not apply to a person who is, 1, in the actual discharge of official duties as a member of the armed forces or state military forces as defined by section 437.001 of the Government Code, or as a guard employed by a penal institution. So if you are that, those statutes don't apply to you. Subsection 2 is the one that is interesting to me. It says, is traveling. So on one hand, 4602 allows for carry in your vehicle and so forth, and then they say here, it doesn't even apply if you're traveling. So it's odd. It's like they enacted this at one point and then they enacted the other and they forgot about it or whatever. So it's interesting that that one's still there. But if you're traveling, also the government meetings one doesn't apply and the street gangs one doesn't apply, which is interesting. So if you're traveling, those don't apply to you. I don't know why they did that, but it is interesting. Number 3, if you're engaged in lawful hunting, fishing, or other sporting activity on the immediate premises where the activity is conducted or is en route between the premises and the actor's residence, motor vehicle, or watercraft, if the weapon is a type commonly used in this activity. So what does that mean? That's a good guess, to be honest. If you are carrying an AR-15, is that commonly used in hunting? You know, people can argue about that all the time. My guess is the intent of this was just if you're carrying a weapon for hunting purposes and you're going between your house, your vehicle, whatever, that you're not supposed to be bothered. Number 4, holds a security officer commission issued by the Texas Private Security Board if the person is engaged in the performance of the person's duties as an officer commissioned under 1702 Occupations Code, or is traveling to or from the person's place of assignment as wearing the officer's uniform and carrying the officer's weapon in plain view. So that's kind of redundant. It's like what we talked about earlier, you know, licensed security officers that have the firearm part of their job, obviously can carry as part of their job. 5, acts as a personal protection officer and carries a person's security officer commission and personal protection officer authorization if the person A, is engaged in the performance of the person's duties as a personal protection officer under Chapter 1702 Occupations Code, or is traveling to or from the person's place of assignment and is either wearing the uniform, like we talked about before, or not wearing the uniform and is carrying concealed. So personal protection officers, bodyguards, if you will, they're licensed differently. They're allowed to carry concealed in plain clothes, or if they're wearing the uniform, it has to be open carry. but they've limited that part. If you notice here, it's only applying to the open meetings stuff and not to the other locations. Number 6 is carrying a license to carry a handgun, Texas license, and B, it's in a concealed manner or in a holster. And so, again, I'm not going to argue with folks about what constitutes a holster. I would just say use your common sense. The statute used to say a belt or shoulder holster, and people thought that they should put their gun in a holster and leave it on their dashboard or leave it on their seat and drive around and see what happens when the cops stop them. And yes, technically it would probably not result in a permanent conviction on your record if you were arrested for that, but there was a chance if you were stopped that an officer would arrest you. There was a chance that a prosecutor would prosecute you. There was a chance that a jury would convict you, and there's a chance that an initial appellate review would leave your conviction in place, and then you're hoping that the high court, the Texas Court of Criminal Appeals, would overturn your conviction. And you hope, while all this is going on, that you're not serving time waiting for your appeals to run, and that you're not otherwise having your life massively changed. So I would say use some common sense, put it in a holster and wear it and leave it at that. Don't push the envelope here. There's no advantage to you doing so. There's only risk to you doing so. If you really feel the need to put a gun in a holster and leave it, on your seat or whatever, then file a declaratory judgment and run that through the court system before you do it, and that way we'll have an official answer from the courts and we'll know, and it'll make it easier for anybody that's wanting to do that. 7, holds an alcoholic beverage permit or license or is an employee of the holder of the alcoholic beverage permit or license if the person is supervising the operation of the permitted or licensed premises. So if you are working in that capacity, basically, I'm reading in between the lines here that it's one of the 51% locations. If you work there, then the statute would not apply to you. The 4602 would not apply to you. Or, so basically when they put or, it means each of these folks are exempt from those. And that may sound weird because normally and is an all and or is either or, but when it's written this way, the or is actually advantageous for you because it means each of these is subject to them. Is a student in a law enforcement class engaging in activity required as part of the class if the weapon is type commonly used in the activity and the person is A, in the immediate premises where the activity is conducted, or B, en route between those premises and the person's residence and is carrying the weapon unloaded. So why they felt the need to put that in, I don't know, but basically if you were in police academy and you were going from your home to the police academy location, then the gun has to be unloaded, or if you were at the police academy location, then you're okay. But honestly, I don't see anybody arresting police academy cadets for participating in the class, so that to me didn't seem to need to be written. Whole bunch weren't changed, so C was previously repealed, so it didn't exist. D says provisions of 4602 prohibiting the carrying of a firearm do not apply to a public security officer employed by the adjutant general under section 437053 government code in performance of the official duties or while traveling to and from a place of duty. I'll be honest, I have no idea what that is, but if you are that, obviously 4602 does not apply to you. Subsection E, 4602A4 does not apply to an individual carrying a location-restricted knife used in a historical demonstration or in a ceremony in which the knife is significant to the performance of the ceremony. Again, that's kind of a weird one. If you were doing some sort of historical reenactment, I don't see the police messing with you, but I guess they needed to put that in writing so we would know for sure. F says section 4603A6, which is the death sentence 1,000 feet within provision, does not apply to a person who possesses a firearm or club while in the actual discharge of official duties as a member of the armed forces or state military forces as defined by 437.001 of Government Code, or an employee of the penal institution. And it just seems like there's so much redundancy with these where they could have just said, you know, active duty military do not apply, sort of thing, but whatever. G says provisions of 4603 prohibiting possession or carrying of a club do not apply to an animal control officer who holds a certificate under section 829.006 of the Health and Safety Code and who passes or carries an instrument used specifically for deterring the bite of an animal while the officer is in the performance of duties under the Health and Safety Code or is traveling to and from a place of duty. So I don't have 829.006 Health and Safety Code in front of me, but I'm guessing that has to do with some sort of training provision for animal control folks to carry. Again, I don't see officers messing with animal control officers if they are doing their job, but we have it in writing at least. H says the provisions of 4602 and 03 prohibiting the possession or carrying of a club do not apply to a code enforcement officer who, one, holds a certificate of registration issued under Chapter 1952 Occupations Code and possesses or carries an instrument used specifically for deterring an animal bite while the officer is A, performing official duties, or B, traveling to or from a place of duty. So again, I don't have 1952 Occupations Code in front of me. I'm guessing that spells out some sort of training provisions for carrying a club. So if you're a code enforcement officer and you get that training, then obviously you can carry the club for your job. I, 4602, prohibiting the carry of a handgun do not apply to an individual who carries a handgun as a participant in a historical reenactment performed in accordance with the rules of the Texas Alcohol Beverage Commission. So that's a really weird exception, but if you fall under that, then you're not prohibited from carrying while you're doing that. My book says that was I, and then the new law calls it J. It says provisions of sections 4602, 4603A7, A-2, A-3, and A-4 do not apply to an individual who carries a handgun as a participant in a historical reenactment performed in accordance with the rules of the Texas Alcoholic Beverage Commission. So I don't know if the book I have has a typo there, because mine goes H-I-K, and it seems to imply that the I on my book was really J. I don't have a way to verify that, unfortunately. So hopefully the legislature will get the codes updated on their website so we can see the exact flow of it. But again, whether there's an I and a J, that's such a small thing. I mean, how many people are doing historical reenactments for the Texas Alcohol Beverage Commission that are needing to carry a gun while they're doing it? Back to the book, not changed K. It says section 4602 does not apply to a person who carries a handgun if, one, the person carries a handgun while A, evacuating from an area following the declaration of a state of disaster under section 418.014 Government Code, or a local state of disaster under 418.108 Government Code with respect to that area, or B, re-entering that area following the person's evacuation. That was enacted, I think it was 2019, and basically when there's a state of emergency, the ability to carry a handgun became legal for you if you didn't already have it. With constitutional carry, that's really no need anymore, because 4602 is not going to prohibit you from carrying anyway. So that's, don't know why they left that one in. Subsection 2 says not more than 168 hours have elapsed since the state of the disaster or local state of disaster was declared, or more than 168 hours have elapsed since the declaration was made and the governor has extended the period during which a person may carry a handgun under this section, and the person is not prohibited by state or federal law from possessing a firearm. So again, we always come back to, if you're a prohibited person, you're not supposed to have a gun, period. I'm assuming that most of my viewers are law-abiding citizens, no convictions, and they're just wanting to know where they can legally carry. So this has to do with the state of emergency situation, and you know, again, it seems kind of redundant when we have constitutional carry now. L was amended, and it says sections 4602 and 4603, A1, 2, 3, and 4, which basically A1 is the schools, 2 is the polling places, 3 is the government court, and 4 is the racetrack. And it says, do not apply to a person who carries a handgun if, 1, the person carries a handgun on the premises as defined by the statute providing the applicable defense of a location operating as an emergency shelter during a state of disaster declared under section 418.014 Government Code, or a local state of disaster declared under 418.108 Government Code. 2, the owner, controller, or operator of the premises, or a person acting with the apparent authority of the owner, controller, or operator authorize the carrying of the handgun. 3, the person carrying the handgun complies with all rules and regulations of the owner, controller, or operator of the premises that govern the carrying of the handgun on the premises. And number 4, the person is not prohibited by state or federal law from possessing a firearm. I'll be honest, that one is not worded very well, because on the one hand it says if there's an emergency and you have to go to one of those locations because of the emergency, you're not prohibited from carrying, but then it goes on to say the person in charge of that can basically say no. Well, guess what? My experience with anybody in any sort of power, it's guns for me and not for thee. So they're going to say no guns there. I mean, I think any place you call, if you go, hey, do you allow guns? Oh, no guns. So that should not have been worded that way. There should be no local person that has the authority to just tell you, no, you can't carry. M was changed. It says it's a defense to prosecution under 4603 that the actor, 1, carries a handgun on premises or other property on which the carrying of the weapon is prohibited under that section. 2, personally received from the owner of the property or from another person with apparent authority to act for the owner notice that carrying the firearm or other weapon on the premises or other property as applicable was prohibited. And 3, promptly departed from the premises or other property. That goes back to what I said in the prior video about 4603. Since negligent carry is not a crime, this kind of solidifies that. Basically, you walk into one of those locations with a gun, they have to tell you, hey, you can't have a gun, and you have a right to leave, and then there's no crime. They added N, which says the defense provided by subsection M does not apply if, so now we're saying they're taking that defense away from you if, 1, a sign described by subsection O was posted prominently at each entrance to the premises or other property as applicable, or at the time of the offense the actor knew that carrying a firearm or other weapon on the premises or other property was prohibited. It still doesn't make negligent carry into those areas a crime, and so bottom line, I think you're going to be fine if you accidentally carry into one of those locations and you're asked to leave, just leave. Subsection O says a person may provide notice that firearms and other weapons are prohibited under section 4603 on the premises or other property as applicable by posting a sign at each entrance to the premises or other property that, 1, includes the language that is identical to or substantially similar. So I don't like that they, previously they had to have identical, now it's or substantially similar, so that's going to leave open a lot of problems, I can tell you that right now. To the following, pursuant to section 4603 Penal Code, places weapons prohibited, a person may not carry a firearm or other weapon on this property. That has to be in both English and Spanish, contrasting colors with block letters at least 1 inch in height, and displayed in a conspicuous manner clearly visible to the public. So if you saw my prior 3006 and 3007 videos, I'm talking the ones from years ago, not the ones I'm going to do for constitutional carry, that contrasting colors thing was certainly a unclear area. I mean, obviously, if you saw letters on clear glass, I would argue that's not truly contrasting colors. Again, nobody wants to be the test case, so if you saw that, you probably didn't carry in that location. But I think it's clearly got to be like a black background with white letters, or white background with black letters, something like that, not clear glass with letters on it, because that's not always easy to see. Subsection P says sections 4603A7, 11, and 13 do not apply. And so just for refresher, 7 is your 51% alcohol businesses. 11 is your hospital. And 13 is amusement park. So very similar to the old 46035 standard. Those do not apply if you carry a handgun on the premises or other property, you hold a license to carry. So this is not for constitutional carry folks, this is just for the license to carry folks. And you were not given effective notice under section 3006 or 3007 of this code, or section 411-204 government code as applicable. So this kind of is similar to the way 46035 used to work. It would say it's illegal to carry on these, and then later it would say unless they didn't give you a notice. Bottom line, I rarely see any kind of hospital or medical facility that doesn't have one or both signs up. I know their thought is, oh, no guns, but they're not understanding that they're basically telling about 3% of the population that's licensed to carry not to carry there, and that 3% of the population is statistically the least likely to break a law, any law. So they're banning guns from the law-abiding folks and inviting the criminals in. And I had that discussion with somebody one time that had both signs up, very prominently displayed, bigger than 1-inch letters, you know, the whole 9 yards. And I said, you know who those signs apply to, right? And kind of looked at me funny. I said, you know, that only affects the license to carry folks. And I was like, yeah. And I said, so it doesn't stop criminals from carrying. And his genius reply was, criminals aren't supposed to be carrying. Okay. I didn't get into the, well, what if they do? Subsection Q says section 4603A8, which is the high school, collegiate, or professional sporting event or interscholastic event, does not apply if the actor carries a handgun on the premises where the collegiate. So see, this is weird because A8 applies to more than just this, but then it says carries a handgun on the premises where a collegiate sporting event is taking place, holds a license to carry issued under the carry law, and was not given effective notice under 30-06 or 30-07 of the code as applicable. So bottom line, what they're saying there is if you take it to a college sporting event and they don't provide you the notice, then you're not breaking the law. Again, it seems that every place has those signs up. You know, their lawyers tell them, oh, you got to ban guns, so you got to put these signs up. I see the no open carry signs up all over places that are already not legal to open carry. So those are a waste of space and money, but you know, they put up these signs everywhere thinking that they're doing some good somehow. Bottom line, criminals aren't going to follow any of these statutes, so they're going to carry. If they want to carry, they're going to have a gun, a knife, a club, whatever, and none of these signs are going to affect them at all. So all you're really doing is the most law-abiding folks that are out reading these signs and trying to follow the law and stay out of trouble are the ones that are going to follow this. And what you are ironically doing is, if they come to your business and they see the signs and they go back to their vehicle to put away their weapons, criminals are watching them and breaking into their cars and stuff. So while you think you're doing good, you're actually arming criminals by doing this. So it's something to think about. And then the last thing they did is the following provisions are repealed. Section 11041 Alcoholic Beverage Code, 1161E of the Alcoholic Beverage Code, 6111 of the Alcoholic Beverage Code, 6171F of the Alcoholic Beverage Code, 411-198B of the Government Code, 411-204D of the Government Code, 411-206C of the Government Code, 4602C of the Penal Code, 4603A-1 of the Penal Code, and 46035 of the Penal Code. I don't have those alcohol or government codes in front of me. The 4602C of the Penal Code was the old provision if you carried into any place that sold alcohol and you didn't have a carry permit. Obviously that's redundant now, so they've deleted that. A-1 was the location restricted knife locations, and it's the same 7 that were typically talked about: alcohol, schools, correctional facilities, hospitals. So that's been deleted. And then of course 46035 was deleted, and that was the places where folks with a license to carry were not allowed to carry, and instead they've moved the relevant ones into 4603 now and just deleted 46035 completely, which was a good thing because 46035 had just too many problems and redundancies and conflicts with other statutes and so forth. So it's good they finally got rid of it. Anyway, that will conclude all of the 46 chapter coverage that I'm doing for this. Like I said, I'm not covering if you're a felon or you have certain crimes or if you have certain convictions or whatever. I'm not covering all that. This is strictly for folks that are law-abiding, legal to own firearms, and just wanting to know where they can carry under the new constitutional carry laws. Also for law enforcement officers to know kind of what these new changes are and what to be looking for and how to treat folks that you run across with firearms. If you have any questions, leave them in the comments, and I'll see